Well, Boyd, we just want to welcome you. Thank you so much for coming on the YouTube show. We're so excited for you to be on Special Education Academy. If we haven't met, I'm Karen Mayer Cunningham, Special Education Boss, helping families navigate and negotiate the 504 IEP process. And so in that, we want to share resources for our families. And Boyd Handley is one of the premier leading attorneys here in the Houston area, providing services for kiddos and individuals and families that need legal protections, which are not limited to guardianships, wills, probate matters, estate planning, especially with a concentration on special needs law. And so SSI, all sorts of things that come up for parents who have a child with differences. And so I certainly wanted him to be able to jump on and share all of his vast knowledge, because a lot of times my families, they don't pick up a service or look into guardianship because they assume what it means. And I'm probably one of those people. And so I wanted to have Boyd Handley on the show and share what he does for families and kiddos. So Boyd, welcome.
Thank you. Thank you. Glad to be here.
Yes. So tell me, how is it that you got into being an attorney? You must have been really good at arguing as a child, and your specialty.
Well, this is my second career. I was a geologist for a little over 30 years, and I had gotten my law degree, and finally, with the oil price changes and all of that, decided to go do something I always wanted to do. We have a daughter with special needs, so I have guardianship of my wife and I. She's be 27 in a couple of weeks. And so, we've been through all the trials and tribulations that all these parents with kids with disabilities or special needs have been through. And it's just a passion of mine. And I'm glad I'm at this stage in my life able to, help them with the legal issues and also help them with understand what they're going through. And so that's how I got to where I am.
Awesome. So, from where I sit, a lot of times families have fear and trepidation about something because they heard their information from, I don't know, cable news or their neighbor who had that experience. So kind of what would be the kind of family that might consider specifically sort of any individual, but specific to kiddos or young adults or individuals with special needs, maybe that were in special education. What would a candidate look like that, and what would it not look like?
Yeah. Well, one of the things, if you've got a child, that's very young and you think that that child may have a disability, we have something in Texas called the waiver list. I always tell, that's those waiver lists or abilities to get money and funds and help from the government here in Texas and from the national. And there's a long waiting line, but I tell my parents, go ahead and put your kids on that, when they're very young. And then, if they grow out and they're not as disabled as you may think they are, then you can take them off. But it's a long waiting line. And, as with our daughter, we knew from the very, fairly early in her life that she was going to have some issues. And of course, we went through all the various steps, between being born and turning 18, there's a whole set of steps you go through. And then unfortunately in Texas, when you turn 18, you're an adult, whether you're ready to be an adult or not. And so, you have a whole set of issues after that. And what I tell my clients is basically what I've done for my daughter. I'm, always looking for, parents to help, whether they're between age of 0 and 18 or after 18. And, that's what, parents are looking for. Fortunately, we have Google nowadays. So whether it's good or bad, you can look up, help and, information. Where when we were first starting out, my wife, Carrie, she has this huge bookcase of books because that's the only thing we could do. So, nowadays it's a lot easier, but, I tell everyone is, you need to get support from other parents, go to these resource fairs, have, representatives and people like yourself in order to call up and help. And, that's just what we have to do nowadays when we have kids in there, because it's so daunting,
Right.
what you have to do. Mm-hmm.
Right.
Yep.
So in the kind of two specifics of guardianship, and correct me if I'm wrong, is there guardianship of the person and then guardianship of the estate? And can
Right.
you kind
Yeah,
of tease that out?
that's correct. Most of the time when our kids are turning 18, we go for guardianship of the person. That's basically doing exactly what they were doing for your child before they turned 18. You do have a bank account and we'll help them with that. Mostly if they're on SSI, then it's a rep pay account. I'm sure a lot of parents have heard of that. The guardianship of the person and the estate is mostly with elder people. And, they've grown up and, have houses and bank accounts and things of that nature. Or maybe a person that's over the age of 18 that's been in a catastrophic accident and they're incapacitated. So that's more guardianship of the person of the state. Mostly, I've done a few of those with elderly people, but mostly it's guardianship of the person for our kiddos that are turning 18. Uh, the reason we have to do that, I tell a lot of my clients is that, if your parents do not have a power, or we're getting a little off, but if your parents do not have a power of attorney or medical power of attorney, and your mom and dad get incapacitated in Texas, the only thing that we can do is go get guardianship of them in order to help them or make medical decisions. So it's really the circle. When we were born, our parents are looking after us, and as they get elderly, we look back, after them. And the same thing with guardianship. You've got the guardianship of the person starting out early, and then as you go later in life, it's mostly the guardianship and of the person, the estate. I may say, a lot of people think guardianship is permanent. It's not. I've got on my website, but I was visiting some of the courts a couple of years ago, and I had a young man who was nonverbal. He had his electronic calculator machine. I call it machine. I'm an old guy. But, you would talk into it, and then he would type and talk back, and we were talking before the court. And lo and behold, he was in the case right before I was, and he was getting his guardianship given back to him. He had gone to HCC, which has a great program for kids with disabilities, and got his computer science degree, and so he was getting it given back. So I tell parents, when they may be on the borderline on whether our kids need guardianship, but we're really just trying to protect them from what's going on in the outside world. And it may be where when these kids turn 18, they're really not ready for going out in the real world. And you can get a partial guardianship if they're fairly high functioning, and then in maybe 4 or 5 years you can give it back to them. So I tell parents is that although we're taking rights away from these kids or young adults, it's not permanent if it doesn't have to be. So
Right. And so I hear lots of questions from my families, and um, a lot of them are fear based. And one of the questions that I get, or the responses, is I want them to be able to vote.
mhm.
And I won't tell you what I think about that now, but I mean, so kind of tell us, Boyd, what is it on onset that rights that you do lose?
Yeah, voting's one of them. I have a number of clients who have guardianship that they're voting. As long as the IQ of these individuals are not too low, then there's no reason for them not to vote. Of course, if you've got certain disabilities that affect your attentionness or you're able to react, then probably driving is not good to be. We have some of the major ones. You take voting, the right to marry, the right to drive, the right to purchase firearms, the right to pick your own residence, and also the right to make medical and dental and psychiatric decisions. So those are the main ones that you do, but I have quite a few that have retained the voting right to do that. One thing I might say is when you have some of these high functioning young adults, I've got quite a few clients that their kids have fetal alcohol syndrome, which is the mother was drinking during gestation and part of the brain is actually missing. These kids can be very high functioning, but they have extreme anger issues. And you may say, well, should I get guardianship for my child with that prognosis? Probably so, because although they could probably sign a power of attorney and medical power of attorney, if they wake up one morning and get mad at mom for not letting them do something, then all they have to say in front of the right people, that power of attorney and medical power of attorney is gone. And so, and also, we want to be sure when we have guardianship of our kiddos, they're not taken advantage of. If they're fairly high functioning, it's like an elderly person. Someone could come in and take advantage of them with a scam project or something. So there's a lot of different things to look at. One thing I might add is a couple of years ago, they passed the where we legally have to try the least restrictive alternatives to guardianship, such as the power of attorney, medical power of attorney, decision-making agreement. So we go through that very heavily with our clients. One thing that I talk a lot about is decision-making agreements. They're actually in the code, in the law for that. But what a lot of parents don't realize is that they can't make a decision with a decision-making agreement. All that does is allow parents to go into meetings with their loved ones and explain what the meeting is about. And the person with the disability has to make a decision. It's good because if they're on the borderline that I may not want to do guardianship or they can't afford guardianship at the time, it's that gray area that the law doesn't say what kind of capacity the young person has to have in order to sign that document, versus the power of attorney and medical power of attorney, which they have to have capacity to understand what they're signing, the risk involved in giving mom and dad that ability. So, it's a great tool in the gray area, but there are limitations to that.
Right. And I hear a big push for that. And that sounds fantastic till what you said, we tear it up and then, it's all, if we could make those supported decisions and I'm sure there's individuals that's applicable to, but when I think of, and I'm sure you get the same calls that I do, I get calls from police stations, I get calls from situations, and I would rather have a great offense than a defense. And there are just countless situations that young people can end up in, whether you had a disability or not, that at that moment, I can't run in and say, I'm their special ed advocate. And you can't run in and say, oh, we were talking about guardianship, because it's either happened or it's not happened. And we know that lots of the judicial system is full of individuals that had disabilities, unfortunate. And so can you speak to that a little bit?
Yeah. Speaking of that, I've got one client that has a 55-year-old son, and the parents are 80 and 85, and he has some mental issues, some drug issues, and they're actually in probate court in Harris County now, trying to get the county to take over guardianship. And it's a big problem with them because they don't have any other kids to look after this individual. As long as he's on his medicine, he's okay. But, we've got, some of these may fall through the cracks, and we have to, just be sure that we take care of them the best way we can. And, whether it's guardianship or the power of attorney, we have to really look at those, because otherwise there's nothing we can do according to the law. We can't, if we don't have those documents, one or the other, we can't do anything for them.
Okay. And what age does it sort of, for me, I think it's a little tiny window, but what age can you start? What age could they start the first filing for guardianship?
You can do it 180 days prior to the 18th birthday. I tell parents give me a call at 8 months ahead of time. We have to have what we call a physician certificate signed by MD or psychiatrist, that's MD. And basically that shows the court how the disability affects everyday life. And that's what we have to prove to the court, that in an everyday sense that they can't do this or that. And so, with the COVID situation, it's very hard to get appointments. And so I say, okay, parents, 2 months ahead of the 180 days, start working on that. And then normally what I tell parents is, let's go ahead and file it, get everything done in court, and then we can wait until the 18th birthday. Most time we can get a court date 2 or 3 days after that. Some of the courts in Harris County, I'm having to get court dates calling 2.5 months ahead of time. They're very full. So, and we're doing everything by Zoom. So all the hearings are by Zoom. Fort Bend County, at least one of the judges said Zoom will not end on uncontested cases. So we're in a different world now.
So kind of speaking to that, when you're doing the guardianship cases, a lot of families want to know, well, are they going to make Billy Smith stand up in court? Is he have to get on the witness stand? What does that look like?
Yeah, normally no. The doctor will actually fill out on the physician certificate whether the child can participate or cannot. Even if they're in school, most of the judges will not ask them to get out of school because these kids have these routines. And the worst thing you can do is mess up their routine, and it really gets them upset in a lot of cases. So probably 90% of my cases, the child is not in court.
And does the court send a representative to meet the student?
Yeah, in Harris County and Montgomery County, they're what we call statutory probate courts. They have the judge has an investigator that actually comes out. Of course, they're doing it by phone call or Zoom now. And then in all counties, the child, unfortunately, they're called wards, proposed ward, terrible name to put on some way. They're all represented by what we call an attorney ad litem, and that's appointed by the court. So that particular person will come out and visit you, most likely by Zoom, and then he or she will represent the child at the hearing in court. Yeah.
And kind of to that, one of the things I share with families when kiddos are getting up in those high school years is I always ask for the school and the local education agency to do a full evaluation in that cognitive piece, adaptive behavior, any functionality, and IQ, because that really helps set up you and your firm so that when we go to the courts, we're not saying, well, this is from 6th grade, because that's not current. Is that helpful for you?
Yeah, the IQ test has to be within the last 2 years. And what happens is that usually that's not done by the physician. So there is actually on page 3 of that physician's directive, there's a box for IQ, and the physician can actually check a box saying he referred another report to another report, and he can check that, he or she can check that, and then put there's some boxes for the total score and can check that off. So basically what that does is give the court information, but then lets the physician not be liable for putting those notes down.
Okay, perfect. And so people always ask me, and I know that I assume somewhere there is, but are there free services with the, I was going to say attorney school, but are there law colleges that offer free services for anybody that you know of?
Yeah, there's a number of like the Harris County Attorney Association, Fort Bend has one, all the Bar Association. They have pro bono work with that. I know there's a couple of other places in town, disability rights, and that will, depending on your income level, they will go forward and help you with that.
Perfect. And so other than guardianship, kind of tell us what else you do as a fancy lawyer.
Yeah, I do a lot of estate planning for folks with special needs kids, or for ones without them. With the special needs, we do, of course, the wills, special needs trust. Very important if your child is receiving or will receive SSI and Medicaid at age 18. That goes about, you can only have $2,000 in assets for these kids that are on the SSI, because SSI is a mean dependent government benefit, meaning that you have to meet certain financial criteria. With these kids, they can only have $2,000 in assets. What that means is that, parents or family members may want to give them something in their wills. So all of that has to go into the special needs trust, where it won't affect their total $2,000 in assets. We do that 2 different ways with families. They can have a special needs trust on the outside. That's the way we have with my daughter. My parents gave her some money prior to in when they died. So we have it there. I personally haven't funded it yet. It's going to be funded by my life insurance, my retirement fund, and my home. If my wife and I die at the same time. The other way is a testamentary trust. What that means is it's a trust that's within your will and does not become effective until you die. And so what will happen is, say you've got two kids, one gets 50% of the assets and the other one gets 50%, but the other one has special needs and his own government benefits. So what we would do in that is that that child's 50% would go into the special needs testamentary trust within your will, and your executor at the time that he goes through probate will set that up with that. And that's how we handle that in the state planning. I also help out with SSI and Medicaid. I've got a number of SSI cases going on now. And then, of course, we do the normal probating your will and helping with that. Mm-hmm.
So then you actually, because people ask me this all the time, do you have an attorney that does SSI? And I assume a lot of things. Is that a service that you provide? Do you provide that after there's a rejection letter?
Yeah, normally I do have a deal where I, help them fill out the application and all. But because what happens is most of these parents, when they child turns 18, they fill it out. They just throw the medical records in. What SSI is looking for is how the disability affects gainful employment. So you have to try to gear the disability on how it would affect the child, either working or if the child has worked some, on why the child has possibly been fired from a job for not, doing what they're supposed to. I normally get calls from parents after they've been denied, and we're getting ready for appeal or in front of administrative judge hearing with that.
Okay. And so for kiddos or young adults, one of the things that we do in special ed that we're supposed to do is transition, right? That we're readying them for post-secondary gainful employment, independent living, and further education. So is it accurate that if you get SSI, you can't have a job?
No, you can make up to, I believe it's $1,250 a month before you lose SSI. What I try to tell parents is that you're probably not going to be able to live on $1,250 a month anyway. So, a lot what we're trying to do with our kiddos is get exposure to people, to the environment. And I say, well, let them make, if they're working, that's great, but let them make about $1,100 a month and be under that $1,250, because the main thing with SSI is Medicaid. It's automatic. You're automatically, approved for that if you're approved for SSI. And of course, that has huge implications as far as paying medical bills and whatnot. So, for the social work and, getting out into the public, that's great. But, as long as you can keep $1 off Social Security, you still get Medicaid. And so that's, what I try to tell our parents.
Right. So if Billy Smith is working and he's making, I don't know, $1,000 a month, how does that parlay into you can't have more than $2,000 a month or $2,000 in assets? Or are they separate?
Well, no, your Social Security will be reduced by making that money, and what you have to do is spend that money each month, where you're not over that on the first day of the next month.
Okay, perfect.
Now, one thing I'll say is that if you're making $1,255, you lose SSI and Medicaid. Well, then you've got to pay for food and lodging. You got to get insurance somewhere. The math just doesn't work out. And so, parents need to keep that in mind.
Sure. So, and then you've told me, like the rest of us, we all work 50,000 hours a day. But unlike most attorneys that I know of, that you have special hours to accommodate parents outside of that 8 to 4 window. Can you tell me about that?
Yeah. Most of the parents, at least one of them, has to work. I mean, our bills that we pay for our kiddos are just astronomical, and sometimes. So I try to work with parents in the evenings, because I like to have both parents on the Zoom calls, and work. I do quite a bit of meetings on weekends because I always like to have both parents together. And so it works out fine with that. because
Perfect.
during the day, it's very hard to get both parents together. Mhm.
And that reminds me of another question. So we have, sometimes people don't stay married and they have a child with a disability. I've had many cases over the years where talk to both parents. I always have, of course, both parents at the meeting. It's their child. And there is a disconnect when they turn 18. Sometimes it's a parent that didn't have custody.
Mhm.
So how do you, if you have two parents that come in for a student, and do they both have to be in agreement on guardianship, or is it tied to their divorce decree?
No, it's not tied to divorce decree. You can have one that wants to file for, well, not custody, but guardianship of their child. If the other one doesn't agree with it, then he would have to file contested guardianship in court. I have a number of clients that are divorced. They're co-guardians. You can also have a biological parent and a step parent as co-guardians, as long as the biological parent waives that right. Now, even though that happens, the parents still have rights to their child. I mean, they're not giving away their rights to a certain degree, but once these kids turn 18, then it's the kid's ability to say whether he wants to visit the other parent that may not be the guardian. And
Okay.
it's their right to decide yes or no. These wards, so these kids that are under guardianship, they have their own rights. They can still go see whoever they want to, as long as they're not in danger. If they're not in danger, you can't call the police and say, please go get my kid. I'm the guardian. He has rights to do that. They have other rights too, that you may not think they do, but as long as they're not in danger, they can almost do whatever they want to. But the guardianship is to keep them out of danger. Mhm.
And I know they've changed it over the years, but if, let's say the parents get divorced and their child with disability is 10, a lot of times now that's written into the divorce decree that, um, that, um, custody child support continues. Is that part of the guardianship?
Yeah, I'm not a family law attorney, but in the code now, it has a specific section for children with disabilities, and for not getting too deep in it, child support continues forever. It may be in different forms, such as life insurance policy or something like that, but uh, normally courts now are doing it. Now, there have been divorces in the past that they didn't know about that. You have
Right.
family law attorneys that do not understand the special needs, and in a lot of cases, these attorneys would hire someone like myself that understands special needs as a consultant to the divorce procedures. But it continues. Now, the one thing in Texas about child support is once the child turns 18, child support is his money. So it affects Social Security. And so, and it can't be, if it goes through the Attorney General's office, it can't be deposited directly into a first party trust.
Okay.
Because of some of the issues that are in the law that the Attorney General does not. So I try to tell parents, if they tell me they're in the process of going to divorce, have the divorced parent that's paying child support pay it directly to the special needs trust versus going through the Attorney General's office, because it's going to really mess up things.
Wow, that was a lot. It just proved that I didn't go to law school and you did. So thank you for all of that. So for families to get a hold of you, to get your services, how do they get a hold of you?
They can call me at 281 703 3616. I've got a website, www.thehandleylawoffice.com, or they can email me at Boyd, BOYD, at the Handley Law Office, all one word. And
Perfect. Well, thank you. I'm sure we'll have you on again. You were just a wealth of information. And thank you so much for the way you serve kiddos. We appreciate it. And so, you guys, if you have any other questions or information that you want to get from Boyd, you can always reach out to me at Karen@specialeducationboss.com. And remember, when we get it right for the child, we get it right for everybody. We'll see you on the next show.